All right, guys. So I heard this news about Harvey Weinstein's one of his cases being overturned, and I'm like, what? Wow. Why? And then when I actually saw why, or one of the reasons why, I thought it was really interesting. So let's check it out from the Associated Press. So, New York Appeals Court overturns Harvey Weinstein's 2020 art conviction from landmark Me Too trial. New York's highest court on Thursday overturned Harvey Weinstein's 2022 art conviction, finding that the judge at the landmark's Me Too trial prejudiced the ex-movie mogul with egregious improper rulings, including a decision to let women testify about allegations that weren't part of the case. The Molineux rule in New York. We conclude that the trial court erroneously admitted testimony of uncharged alleged prior acts against persons other than the complainants of underlying crimes. The court's 4-3 decision said, the remedy for these egregious errors is a new trial. The State Court of Appeals ruling reopens a painful chapter in America's reckoning with sexual misconduct by powerful figures, an era that began in 2017 with the flood of allegations against Weinstein. His accusers could again be forced to relive their traumas on the witness stand. The court's majority said it is an abuse of judicial discretion to permit untested allegations of nothing more than bad behavior that destroys a defendant's character but sheds no light on their credibility as related to the criminal charges related against them. Now, if we hop over to People magazine, we get this extra quote. The overturning of the convictions comes after Weinstein's lawyer, Arthur Aidala, claimed that his client didn't receive a fair trial due to the judge, James Burke, while further claiming that Weinstein's character was put on trial rather than the evidence. Now, why do I think this is relevant, especially in New York? So, let's get a quick summary from the New York Law Journal. The Molineux misstep in Jonathan Major's assault trial. In a criminal case involving domestic violence in New York, a favorable Molineux ruling may occur when the judge decides to exclude evidence related to the defendant's prior bad acts, specifically a previous fight, despite the prosecution's attempt to introduce such evidence. Now, this starts off by talking about how he was found guilty. The icing on the cake for the jurors seemed to be the text messages from a past fight that the actor had with the complainant. From a criminal defense attorney's point of view, this is an unfortunate and seemingly preventable result based on Gaffey's initial Molineux ruling. Originating from the landmark case of People v. Molineux, the ruling establishes the guidelines for the introduction of prior bad acts or other crimes as evidence against the defendant. Molineux has played a crucial role in deciding whether evidence can be presented against defendants in a criminal trial. The principle of Molineux generally prohibits the introduction of evidence regarding the defendant's prior bad acts to demonstrate a propensity to commit the charged crime. However, Molineux allows for exceptions when such evidence is relevant for other legitimate purposes, such as motive, intent, identity, completing the narrative, or a common scheme plan. In a criminal case involving domestic violence in New York, a favorable Molineux ruling may occur when the judge decides to exclude evidence relating to the defendant's prior bad acts, specifically a previous fight, despite the prosecution's attempt to introduce such evidence. That's exactly what happened in Major's case. At the beginning of the trial, the prosecution sought to introduce evidence of a September 2022 fight between the defendant and the complainant as part of their strategy to complete the narrative. So, give the jury whole narrative. That's what the prosecution wanted to do, they said. Or to explain the victim's actions of not going to the hospital for treatment on the night of this incident. Alleged incident. At the Molineux hearing, the defense contended that the prior fight was not sufficiently connected to the current domestic violence allegations and that its prejudicial effect far outweighs any probative value. The judge agreed with the defense and kept out the testimony regarding the prior September 2022 assault. Alleged assault. So, there's some filling in the blanks or creative licensing going on here with this article, as well as the text messages concerning that assault. The ruling ensured that the jury will not be swayed by unrelated prior bad acts and allows the trial to focus on the specific facts and circumstances of the current incident, the March 25th assault. Yet, that was the expectation before the trial started. But what happened with the trial? When we look at the proportion of testimony from the key witness besides the driver who said she was doing everything, he was doing nothing. The other key witness, Grace Jabari herself. What proportion of her testimony was about March 25th? The Molineux ruling is not without restrictions, though, which is where the concept known as opening the door comes into play. The doctrine of opening the door constitutes a pivotal element within Molineux rulings, activated when the defense, whether by design or oversight, introduces evidence related to the defendant's prior bad acts. By presenting such evidence, the defense may open the door to allow the prosecution to respond with evidence that would otherwise be excluded under traditional Molineux principles. In Major's trial, that door was opened during cross-examination of the complainant when defense attorney Priya Chaudhry asked why she didn't seek medical treatment following the March assault. In doing so, Chaudhry inadvertently paved the way for prior text messages and testimony concerning the September 2022 assault to be introduced. Consequently, Gaffey permitted the prosecution on redirect to present the text as evidence. Now, I have a bone to pick here, because when you look at that line of questioning, it wasn't exactly, well, why didn't you seek medical treatment? Line of questioning was, you're saying you didn't tell someone? And poking away at that, the idea of telling somebody, which is going to be an interesting point of contention now that in Grace Jabari's civil suit, she is making the argument that she told friends and family what was going on. So this is a little bit, I think, a mischaracterization. But mischaracterization aside, we're still talking about this Molineux principle in a New York court after just seeing a New York high court be like, hey, that's prejudicial. And here, we're getting the argument, why does it matter? Why does it matter that it came in if it was prejudicial? Well, the revelation of the previous assault, and we don't know, they keep saying previous assault, but it's an alleged previous assault. That's not a fact on the record at all. In Major's testimony proved to be a decisive moment, effectively concluding the trial in the eyes of the jury. Majors did not testify in his own defense. And I would argue that another reason that this is problematic, this Molineux rule, and in the way that it can prejudice a defendant, is evident in this article, because we've seen this author who's trying to just make a point about Molineux evidence. They incorrectly keep asserting that September 2022 was a previous assault, but that's not a fact on the record. That's not something that's been tested. In fact, when Grace Jabari was asked to read the text, there was no questioning, zero questioning whatsoever about what those texts were relating to, what they referred to, what happened in that surrounding circumstance for those text messages to have been sent. No testimony whatsoever. They just read the text messages onto the record and then moved on to March 25th, 2023. So, a completely untested previous incident being used to precede a question to Grace Jabari of, do you know who injured you on March 25th, 2023? To which she said, Jonathan Majors. So, I was shocked to see this news, and it was very interesting when I saw why. Untested previous allegations being presented in front of a jury. The Molineux rule. New York's highest court says that's problematic. But let me know your thoughts, you guys. I've got a lot of work I got to get to do. But yeah, let me know if you saw this news and you saw the reason why. Let me know if you didn't see this news at all. Let me know if you're shocked at the reason why. And let me know what you think of the broader implication for the Molineux rule. And what it means. Do you like it? Do you think it has problems? Do you think a New York court making this decision could have any bearing on what happened with the September 2022 text messages in the Jonathan Majors trial? You guys let me know. The floor is yours. Take care.